and shine. Coffee's brewing, feeling fine. News is out and on the air. Shizzywhiznut's wild, but we don't care. Morning whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzywhiznut, start the show, let's go. Get it, yeah, oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java with a smile. Pants are off, but stay a while. Morning whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzywhiznut, start the show, let's go. Get it, yeah, oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java, wear a smile. Pants are off, but stay a while. Morning whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzywhiznut, start the show, let's go. Get it, yeah, oh yeah. Serious is overrated. Every day we're caffeinated. Talk the town, but in a jest. Morning whiz is always best. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop.
Oh my god, Shizzy breaks Larry. Shizzy broke Larry.
Good morning, everybody. How are you doing? Yes, it's a beautiful Tuesday, and we are going to have a little bit of fun today. How are you doing? Good morning, Denise. Good morning. We also have BJ has become a new YouTube member, and you know exactly what that means. Yes, it is.
Welcome to the shit
Yes,
show.
it is.
Every single day.
Every single day.
A new flavor of fuckery.
'Cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday.
And then 4 more days of increasingly stupid, ridiculous,
Ignorant, balder, dash, poppycock, bollocks, and buggery.
It all over again.
Oh, yes. Now, good to see you this morning. Good to see you, BJ. I hope you're doing well. Jane Chu has been a member for 3 months and love it here. Honestly, brightens my day well.
Welcome to the shit show.
Most definitely. I am so glad. It seems that you've been here a lot longer than 3 months, though. I think that's probably true. It does happen. It does happen. Yes, we are going over an older case, and this is showing how someone has misbehaved in some really serious ways. And this came in, just, what was it, yesterday? The day before yesterday? I've been so busy, I hadn't even really noticed this because I've been working on a whole bunch of stuff in the background. Afternoon, Shizzy, and all in chat. Welcome, Lisa Farr. And we also we have Jane. It's hello, everyone watching from the UK. Yes, most definitely. Glad to have you here. It is wonderful. It is wonderful. And we have this right here. Now, if you hadn't seen this, this was on 5/27/2025. This is the arresting agency, shows the booking number. And also shows, amazingly, that this is a dude. What? I saw this. I was like, you've got to be kidding me. A dude. It's not a dude. Well, it could be a dude. I mean, I have no way of confirming that. But that's a little scary. I mean, it's a little scary. Hair is long. Good afternoon. Good morning, everyone from Iowa. Welcome, Benny. How are you doing? Welcome from Iowa. Yeah, we won't make any Iowa jokes here. No, I'm just kidding. We will. We make jokes about everything, especially me. Hey, you're new. Well, good to see you, Gene Hopper. You're not new. You're not new. You're right where you're supposed to be at the time that you needed to be here. Welcome. And yes, this is Maricopa County Sheriff's Office identification information showing that there was an arrest made. So interesting that this person has done some things that have gotten her in trouble, and it's those hits are going to keep on coming, which is sort of a spooky kind of thing to think about it, that you get in trouble for perjury. Even if it's a little perjury, you can get in trouble for it. Now this here is going back to the Laura Owens v. Greg Gillespie, August 17, 2022, Scottsdale, Arizona. And we're going to probably be doing this in multiple parts because this is about an hour hearing, and I don't have that much time to be on here today. And we're just gonna observe. What? What? Yeah. What? Yeah. Somebody got themselves in a little bit of trouble. Now, if you want a brief rundown on this, I'll be putting one out later that has a little, so I can get you all caught up to all of the stuff that's going on with this. Good morning, Jenny, 8675309. That's right. Don't want to lose that number. No, this is going to be, then this is presented by and I'm going to say the name completely wrong. It's Schnitzel Ninja, which has collected all of these. And if you're looking for that particular channel, it's posted in the description there. Make sure you go check them out and show some love. All the videos that I'm showing from this are coming from there, and want to make sure that they get the kudos for collecting this information that they deserve, and actually having it up there. There's quite a bit. We're going to be going over a lot of that, because when this one actually goes in front of the Maricopa County DA has brought charges against Laura Owens for 7 counts. I mean, it's not shallow the kind of trouble that she got herself into for lying to the court. My goodness, that was fun last night. Reminds me of a lyric or two. Oh, what a night. Oh, yes, it does. It was definitely a fun time last night. Yes. And we've got some more. Just love the laughter every time. Guaranteed to laugh at the song you play cracks me up. Well, we'll have some pretty interesting music coming out the next couple of weeks. And we will probably be seeing some videos that someone believes have been yeah, we'll just go into that later. We'll go into that at the right time. Just love the laughter, and that's what it's all about. It's about having some laugh. This channel is all about satire and fun and making a mockery of the shenanigans that we see. And this has been one of the core parts of this channel, and don't want to lose that direction. So let's get into this thing. This will be good. Here we go.
We'll go ahead and call the case then.
I'm gonna bring up audio a little bit here.
Good afternoon. We are now on the record in CD 2021-052893, Owens versus Gillespie. This is the time set for oral argument.
Now, if you haven't noticed, this right here is Greg Woodnick. Now, Greg Woodnick is the one. Good morning, Mama Cuddles. Debbie Webb. Love it. Thank you. Lawrence Owens, maybe throw her a stash out. Might grow one. She might. She just might. Yeah, I made it. No mowing the merry morning. Have a headache. Needs laughter. Oh, well, we'll get you some laughter. We'll get you some laughter. So Greg Woodnick is the one that represented Clayton Eckert in the case that for that paternity case. Basically, the judge ruling on she was never pregnant. And if she was, he wasn't the father, so there's no paternity issues there. Basically, she got destroyed on that. Now this is a different attorney for Laura Owens. This was the first. This is going to be a really good one. It just shows your autocorrect is getting worse. Ugh, yeah. So let's give it, and if you have any serious questions, there's people that followed this much more, such as Megan, Megan Fox, she covered this. There was also Lauren that covered this extensively. Rosalind Duke covered quite a bit of this, and there's a multitude of people that probably have more information on all of this than I do. These are things that I haven't seen yet. So they'll come as a quite a new surprise to me. And this is Greg Gillespie right here. You can tell that Laura has a particular type. She likes guys with mustaches more than she has.
On the motion to dismiss that was filed, motion for judgment on the pleadings on February the 15th after our continuance from last week. Can I have your appearances, please, for plaintiff?
Yes, Kyle Oldwire on behalf of plaintiff Laura Owens, who it appears is also in attendance for today.
Thank you. Welcome.
She's in attendance.
Good afternoon, Your Honor. Marcus Reisinger on behalf of defendant Greg Gillespie. Greg Woodnick is also in attendance, as is Mr. Gillespie himself.
All right, thank you. Welcome.
Mm-hmm.
All right, counsel, any preliminary issues you need to take up before we get started? The court has read the...
But we've been told we can't take Megan seriously because she laughs too much. I am crushed. If you cover being laughed at relentlessly, yeah, exactly. But, we've been told we can't take Megan seriously. Well, why would you want to take Megan seriously? As she likes to state, she is medium smart, and you can't take anybody that's medium smart seriously. If you do that, well, then that might make you like medium smarter. It was a full beard and stash. Well, that's just, there's nothing wrong with that, Mary. Just
abuse of the parties, of course. We have the time divided equally between you. I will say that you don't need to use the full half hour that you've been provided. That's a question that the court often gets. Don't feel like you have to fill up a half hour if you don't need a half hour. But I found that half hour total for both sides tends to be a little short, and I don't want to stress people out. So
for you, maybe.
Build in a little bit of a cushion there. Any preliminary issues we need to talk about from either side? For plaintiff?
No, thank you, Your Honor.
No? All right. How about for defendant?
No, Your Honor.
Okay. All right. Well, with that, we'll just get right into it. It is defendant's motion, which means that he'll go first. So his attorney will argue.
I don't know what to believe anymore. Shizzy's doing a show he said he couldn't do. LO apparently has doing him giggleberries. The expert didn't take credit for button pushing. My world is a lie. It's a lie. It's a lie. Woodnick looks a little wild on Zoom, but in person, not so much. Yeah, I mean, he does have that unkempt look about him, but he seems to be pretty solid. Seems to be a pretty solid guy. To hear the court, I got my headphones on max, so be careful, Shizzy. Now you are loud. All right, I can bring mine down just a little. I've got it turned up on that side a little bit, so let me just bring it down to about there and see if that doesn't tone down on my voice just a little bit. There we go. That should be a little more tolerable. All right, here we go.
First, and then we'll hear from plaintiff's counsel. And then if defense counsel has saved any time, and I'll be keeping time as well. So if you need a time check, just let me know. But if defense counsel elects to reserve some time, then he'll get the last word on the motion by way of rebuttal argument because it is his motion. So that's how we'll proceed this afternoon. All right, so we'll look forward to hearing what you have to say. On behalf of defendant, go ahead.
Thank you, Your Honor. I will attempt to reserve 5 or 10 minutes for rebuttal, and I'll try to keep my own time as well. I'm going to start, I may go a little bit out of order from the way the arguments are presented in the motion, but I'd like to start with the pleadings themselves, because that seems like the straightest line to the resolution we're seeking here. On its face, the complaint alleges various acts and conversations that Mr. Gillespie and Ms. Owens had. I'm assuming for the sake of the standard on a motion for judgment on the pleadings that all of these well-pleaded facts are true, certainly not admitted, but are true for purposes of the motion. If we do that, we find that the acts that Mr. Gillespie allegedly engaged in don't qualify for the relief that Ms. Owens is seeking under Title 36, 2153. The reason for that is the statute says a person shall not in any way intimidate or coerce another person to obtain an abortion. Intimidation and coercion are terms that are not defined in the statute or really readily defined anywhere in Arizona law. But in the motion, I've pointed out 2 places where those terms appear.
Thanks, Winston.
In Title 13. And in both of those instances, they speak to not just persuasive speech, but truly intimidating and coercive conduct, such as threatening violence or actually engaging in acts of violence to cause another person to do something. The other example in Title 13 relates to sex trafficking. And again, the conduct that's prescribed there is actively threatening someone's safety or their legal standing or withholding a substance from them on which they rely physically. So all of these things are conduct more than just speech. We can imagine a scenario in which a person threatens someone else and says, "You're going to obtain an abortion today, I'm going to drive you there, and if you don't, I will hurt you." And certainly that would be intimidating or coercive. Yeah. But that's not what's alleged in the complaint. In the complaint, there are many allegations relating to going on a trip, pursuing a long-term relationship, getting married, meeting Miss Owens' family, etc.
Wow, sounds familiar.
None of these are threats of harm. None of these are coercive in the sense that those terms are used in Title 13.
Is this a new one? Which dude is LO? I can't see beyond the bush. No, she's present, but she's not on camera. But she is present there.
The alleged behavior that seems closest to potentially being coercive is actually a promise to do something good, not something harmful like the other examples. The only thing that, again, assuming all the well-pleaded facts are true and reading them in the light most favorable to the plaintiff,
it's all right.
There is this allegation that Mr. Gillespie threatened to, quote, go public with the abortion. But as stated in the complaint, if that occurred, it occurred after it was already completed. So that behavior, that conduct, or that comment must be excluded temporarily because it couldn't have been intimidating or coercive prior to the abortion taking place. For that reason, the complaint itself simply fails to state a claim for which the court can grant relief, assuming all of its well-pleaded facts are true. Next, we've questioned whether Title 36, Section 2153 actually creates a cause of action against an individual. The statute is long and sort of meanders through various different topics, but the overwhelming majority of these subsections speak to acts and requirements of abortion providers, medical providers. The statute requires certain notice to be given and a timeline for that to occur, ways of documenting informed consent, certain information that a provider must give to someone before performing an abortion. None of those things speak to the conduct of a private individual. The only section that arguably could, which is this very broad subsection G, simply says a person shall not intimidate or coerce in any way any person to obtain an abortion. But then that section goes on and talks about a parent or a guardian coercing a minor child to obtain an abortion, and what occurs if the family denies financial support to the child.
It's always a
So
possibility.
even reading
I mean,
that section in a vacuum without
depends
considering
on
the other subsections of
how
the
much.
statute suggests that the kind of conduct that's prohibited is not something that
Thank you,
Mr.
Starcy.
Gillespie could have engaged in. Further down in the statute, there's a mention in subsection L of a civil section filed pursuant to subsection K. But subsection K references an abortion being performed without informed consent as required by this section. So again, the only section of the statute which appears that it could create a private cause of action against an individual is limited by the language of the statute to a person who's performed an abortion without informed consent. And then the statute defines in various ways what that consent looks like and what things need to be done. But none of these are conduct that a private individual could engage in, unless I guess they performed the abortion themselves, but that's not what was alleged here. So given the
so I mean, she's, you know, according to all of these things, how many times has she been pregnant? How many kids has she? What would be that she's not had? How many kids has she not had at this point? You know, that we know of, because if I'm not mistaken, was it Greg Gillespie or somebody else that was before? I think Greg was the last one before Clayton, and then there was one before that, and another one before that. I mean, it's a crazy amount. Yeah. Sues Listerine for spontaneous abortions. Shit never sleeps. Well, I did, and I missed last night's. Any good? Yes, it was. And if you haven't, reach down there, hit that thumbs up. If you're not subbed up, sub up, because you know, I gave out, what was it, 10 gifted memberships last night, and there was, I think, another 20 or 30, something like that. It was an insane amount of memberships were being given out last night. We were having a lot of fun. Ah, yes, he's he's never number 2. I don't know. They have to update the physician's desk reference if this pans out. Say what?
Tweeting and the conduct that's been alleged and the language of the statute itself, there is no claim here for which the court can grant relief for what I'll call abortion coercion as shorthand, because the claim itself is not really defined in the statute. Moving on and assuming for the sake of argument that there is a cause of action against a private individual under the circumstances.
Hope you're having a good day.
We've alleged that it is impossible for the court to afford complete relief with the existing parties. And the reason for that is because the statute clearly requires conduct of a medical provider who conducts an abortion. But no such provider has been joined here. And even if we read the complaint and assume all the facts true, there was no abortion procedure performed here by a third-party medical provider. The acts alleged that caused an abortion under the complaint, assuming the facts are true, were acts by Ms. Owens herself. All of the acts, most of the acts, as described in the motion, occurred outside of Mr. Gillespie's presence. They, according to the complaint, were done for reasons that really had nothing to do with coercion. It was, in Miss Owens' words, because she wanted to maintain a relationship with him.
Yeah.
Promising to do something, even if the promise is known to be false at the time it's made, is not intimidating or coercing. You could
Oh, wow. Yeah.
argue that it's bribery or some kind of fraud, but that's not what's been alleged here, and we're certainly not admitting that. But again, there's a categorical difference between offering to do something good and threatening to do something bad and its coercive effect on a person. In the statute, the language that's used suggests we're talking about doing something bad, not promising something. If a claim exists, then the provider themselves.
Larry, that's bad. That's bad. Honestly, you're killing me, Larry.
Must be joined. If there is a provider here, then arguably it would be the person who provided the drugs that Miss Owens used to perform the abortion.
Mm-hmm.
We don't know who that person is, and we certainly can't join them ourselves, nor is it the defense's obligation to do so. But the claim fails because the court cannot afford relief under this statute for this claim without including the provider, because that's the
Yo, I'm not sure about that horse HCG thing or whatever, but allegedly someone stomps out numbers when she counts. She can't count any higher than 4.
person who is required to obtain informed consent. That is the person who's required to document that informed consent. And arguably, Mr. Gillespie may be indemnified if there were a claim by the person who conducted this abortion without informed consent, because the duty here to do that is on the person who performs the abortion, which is not Mr. Gillespie, and it's not alleged that he's the one who performed it. All of these arguments thus far for improper joinder and the judgment on the pleadings are really limited to the pleadings themselves, Your Honor. The claims I'm going to
Good morning.
motion now that I'm going to talk about is relating to the constitutionality of the statute. So we're taking a little bit of a different approach.
All right, can we just pause there for a moment? So looking at subsection K of the statute.
This judge is on top of it.
When I say the statute, I'm talking, of course, about 36-2153.
Yes.
So for shorthand, the court will just refer to it as the statute. So when we look at subsection K, the very first clause in it says, in addition to other remedies available under the common or statutory law of this state. So wouldn't that defeat some of your argument about having to satisfy numbers 1 through 3 of subsection K?
I don't think so, Your Honor, and hopefully I'm understanding your question correctly, but there's another claim in the complaint for intentional infliction of emotional distress. That could arguably be one of these common law remedies available that we're not moving to dismiss based on the pleadings. We may move for summary judgment on that issue if Ms. Owens complies with her disclosure requirements or doesn't. But this statute, this subsection K, seems really just be limiting a claim for a violation of this specific section of Title 36.
Okay.
Maybe she was going for unicorn. Maybe that's what it was. She was going for unicorn.
And
I hear it's
the
really
court
tight.
agrees with you that
Just a tight trip,
the
man.
definitions in this statutory.
Oh, this is before Gingras. This isn't even Clayton Eckert. So if you're wondering what happened to Gingras, this is before Gingras. This gentleman right here, is Greg Gillespie. Okay. Now there were, and we'll go into that a little bit later, but the issue here was similar to what happened with Clayton. Her claiming to be pregnant, deletion of a child, all that kind of stuff. Now she's brought suit against him. All right. Now this attorney right here, Greg Gillespie, or is one of Greg's attorneys, but he's also eventually moves on to take care of Clayton Eckerd's case. This attorney right here is the attorney for Laura Owens, and this is another attorney that's for Greg Gillespie. This is the one that's been handling the case. So he's the one that's handling the case, and of course Greg. So we'll put Greg Gillespie, and then you've got Woodnick right here. Woodnick right there. And of course you have I forget this guy's name, but this is Laura Owens' attorney. So he's the one that's handling this suit against Greg Gillespie. This guy right here. So it's Laura Owens versus Greg Gillespie, and then you've got this guy that's representing him, and Greg Woodnick. That's I believe handling the case. It's out of his law firm. Yeah, there's a lot of moving parts. I still think that the Vashbirth, the I would probably agree. That'd probably be a little bit better to handle. Does she have a PO against them all still? I believe that is true. That fled the country when Larry's sex was revealed to America began to share it. Does she have a PO against them all? I believe that is correct. Except for I don't think she has one against Eckerd. I think she still has one against Gillespie. And the name slips me. It's early in the morning. I can't remember names worth a damn to save my life. So I believe she still does have protective orders. And this one was renewed just recently on Greg Gillespie. Not this particular one, but well, it is this particular one. But yeah,
scheme are obviously not inclusive. So if we look at 36-2151, which is entitled definitions, there certainly isn't any definition of intimidation, of coercion, or really anything similar to that the court could find.
Yeah, Mike and Greg. Mike
so
Maraschini, I think that's right. Maraschini.
Not helpful as far as interpreting the term intimidate or coerce as used in subsection G. But it does go on to talk, and perhaps this sounds like.
Well, and I just, I don't wish anybody to be in jail. I mean, that's one of the worst things on somebody. But, if she does do the crime, then, and she does the time and she serves her time, then hopefully that's a deterrent from her to continue doing these kinds of shenanigans and causing people not only grief but monetary grief, and the amount of, and it also may, I hope she learned from this. I really do, because that would be the best outcome from all of this, is for her to not ever do this again to somebody else. She needs to be banned from the internet. That is a possibility. She will accuse jail guards as well, I bet. Mark my words. Yeah, that wouldn't surprise me if she is in jail. Except most of those jails have female. I mean, she's not going to enjoy her time there. And I will say, if we've seen anything from women that end up going to jail, they tend to put on the pounds quite a bit. They really do. So she's going to go from her, or what is it, 90 pounds at the time of going in there to, I mean, she's going to pack it on. I mean, look at Sarah Boone. She really packed on the pounds whenever she got there. Bill, she thinks it's time for alfalfa. Well, different kind of alfalfa.
Go to what you're arguing about next, which is about the constitutionality of the statute itself. But by using the phrase "in any way," isn't the legislature signaling that it doesn't wish to be limited by perhaps what was included in Title 13. And it sounds like perhaps you can fold that into your comments about constitutionality, but go ahead.
Yeah.
I will, Your Honor. And just as a preliminary point, in order to challenge the constitutionality of a statute, as the court knows, we're required to provide notice to certain government officials. We have done that. I noticed after the last hearing that we haven't filed those affidavits of service, but they have been filed and they're on ECR now.
Yes, we saw that. Thank you.
And so, yes, I believe that the language of the statute has numerous flaws, which we've pointed out. But the one you've just highlighted, Your Honor, is the one that really creates the biggest constitutional problem, and that's intimidate or coerce in any way any person. So we have two very broad categories here. One is the target of the intimidation or coercion could be anyone. There's nothing limiting this to a specific set of circumstances, a relationship between the two people, whether they spoke face to face, whether the speaker intended to reach that individual or even knew that that individual was pregnant. Those things, as I discussed in the motion, are all incredibly broad and vague. But then this in any way language in the statute, again, I believe that the legislature's intent was, as Your Honor has stated, to not limit intimidation or coercion to a specific definition or a specific set of words or conduct. But by using such broad language, the legislature has necessarily swept in protected conduct. So, for example, a person could make a comment to another person, I believe bringing a child into the world which was not planned or which was not in wedlock is unethical. Well, that could be coercive or intimidating depending on the relationship between the two people or how it's said. But clearly that's protected speech. It's really just an expression of a philosophical standpoint. It's not the kind of conduct or aggressive language that we see in the Title 13 definitions of intimidation or coercion. And so the legislature may have intended to broaden those definitions by saying coercion or intimidation in any way.
Where there's not anything in it. I'm sorry, I should have said that.
Qualifies as actionable under this statute. But just because the legislature intends to do that doesn't mean it's permissible under the law. There's plenty of case law suggesting that certain kinds of speech and behaviors are protected. Even after the recent Dobbs decision, things like the zone of privacy are still intact based on the language used in that decision. And so this language here is simply too broad for an individual to know, one, what kind of conduct is actually permitted or actually prohibited by the statute. Two, what kinds of remedies or what kinds of penalties may exist for doing so. I'll touch on that point again in a second. But also what kinds of speech is permitted and which is not. And so in a way, the statute also acts as a form of prior restraint based on the content of one's speech.
Squeeze my
hog.
hog.
It doesn't say that there can't be a conversation within a specific sort of set of parameters. The statute could say that there can't be a broad discussion of abortion in a way that incites a riot, for example, or in the context of physical violence or intimidation or coercion. But it doesn't. It says, shall not intimidate in any way any person. So really, it's all sorts of speech. And it's almost impossible to know where the line is, where you've crossed over from suggesting or persuading a person and into intimidating or coercing. And nothing in the statute.
Well, and he does have a fine point there, because there's a, at what point does making a statement as compared to making a demand, does that become intimidation? So he's making a pretty valid point there. If someone's just making a statement saying, well, my belief is, and I'm just using this as an example, my belief is that, women shouldn't have kids, because that's one of your core beliefs, as compared to, pointing it out and getting up in somebody's face and saying, well, my belief is this, and so you should do this. that could be seen as intimidation. But if it's just, sharing of value, is it actually intimidation? I mean, because, intimidation, I guess, would be in the eye of the beholder. So, looks like a short-haired. No, not even close. Not even close. Oh, no. Valhalla has a much smoother look. Even as rough as he looks, he's much smoother. If you met him in person, you'd understand. Hey, Allie, good to see you. Hi, Shizzy, much love. Thank you very much. I appreciate you.
Does or even could prohibit suggesting or persuading a person to do these things, because clearly that would be protected speech. Only when the speech is either accompanied by conduct or is so severe in itself that it crosses over that line into intimidation or coercion can the legislature bar that from occurring.
Yeah, that's where it's going to become a pretty big issue. Like for her. Well, it reminds me of Val. You just like the beard. That's all. I know how it is, Nanny Goat. You just like that. You just like that manly old beard that man has. You just like, oh, he's so masculine. Gotcha. It's because he plays with the goats. He plays with the goats. You know what? I need more coffee. Okay, so what I'm gonna give you a heads up, because the reason I'm giving you the heads up is because whenever I play this, it's gonna get much louder than what you currently have right now. So if you're listening, count to three, and on the count of three, whenever I start counting on the count of three, that music's going to kick in, and I'll be back in 3 minutes and 30 seconds. So 1, 2, 3.
Sandy shores, get a tan, Rambo the orangutan. Driving a golf cart, oh man, Rambo is half crazy, yes he can. Well, that SOB's a sight to F and see. Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Whoa, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is, well, that is too dirty to say here. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is a, that is too dirty to say here, Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Otters in the surf, hummingbirds in the sky. Rambo honks the horn and spits in Shizzy's eye. Oh my! Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Oh, Rambo's rolling. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand otter, it probably wasn't nice. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand otter, it probably wasn't nice. Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having a effing blast. here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too. Well, here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too.
All right, back to regular volume so you can turn it back up again because, like I said, this is going to be really soft. I can't do much about that. And I do have a letter for you guys today. So stick around for that because it's going to be fun. It's going to be fun. I hope you enjoy it. Oh, yeah, here we go. Good morning. Good to see ya, Magic Angel. Yes.
Sorry, I skipped around a bit in the direction I was going to head here, so let me collect myself briefly.
Sure.
Hey, while he's collecting himself, welcome.
Welcome to the shit show.
Thank you.
Every
Greetings from
single
Belgium,
day.
coffee.
A new flavor
Thank
of
you so much,
fuckery.
heroes.
'Cause everybody's such, you see, and they're dumber than a bag of rocks. Monday, bullshit. Tuesday, bullshit. Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, boulder, dash, poppycock, bollocks, and fuckery. We'll have it all over again.
Thank you so much, heroes. I appreciate you. All right, here we go.
Take your time.
Okay, so I was going to circle back around into the zone of privacy. The statute is concerning because it sweeps up protected speech. And the
no, it's
reason
not.
that we know
Different
some of this
judge.
speech is protected is because the U.S. Supreme Court has given us certain circumstances where conversations between private individuals
This is
are
Alison
given
Bacchus.
heightened protection as speech that involves a fundamental right or is within the zone of privacy set forth in the Griswold versus Connecticut decision. In that decision, the court said the First Amendment has a penumbra where privacy is protected from governmental intrusion. And this statute certainly appears to invade that space because a person having a private conversation with their spouse or their significant other about an abortion goes directly to the kinds of relationships and the kinds of contexts in which this zone of privacy grants heightened protection to that form of speech. Things like a decision whether to bear or beget a child, which is a fundamental right under the U.S. Constitution. If that is the case, and it seems to be, then this prohibition against speech would have to overcome strict scrutiny, meaning that the government would have to have a compelling interest in regulating the speech and must also do so in a way that's narrowly tailored just to achieve that interest and not sweep up any more protected speech than necessary. So arguably, had the statute read a person shall not intimidate or coerce another person to obtain an abortion and didn't have this broad in any way language, it might survive strict scrutiny because there it's more narrowly tailored. But here we have arguably, and I'll concede for the sake of argument, a compelling interest to try to protect potential life. But the narrow tailoring is certainly missing here. This is about the broadest tailoring you can possibly imagine. The only way it could be broader is if the statute said a person shall not intimidate, coerce, or persuade, or suggest. There could have been additional forms of conversation that it sweeps in, but the language as it's written is extremely broad and clearly invades that zone of privacy, that sphere where individuals are permitted to communicate with one another in order to exercise and contour their fundamental rights and the relationship between them.
Yeah, he's making some pretty valid points. I mean, if you think about it, you know, just the mere suggestion she could consider intimidation according to the statute. Just the mere suggestion. And because this is the problem whenever you have laws that are overly broad because they haven't either they never flushed the whole thing out, or they were just being lazy and not wanting to overstep or anything like that. I mean, according to the statute, there would be no difference between him, waterboarding her to make her, have a deletion there, or him just making the suggestion because it's so broad. Just him making the suggestion, according to the statute, would make it look like he's being coercive. Even just discussing it. And that takes away the ability to have like a conversation between two intimate partners. So he's making a really valid point on this.
And so to the extent that this statute acts as a prior restraint on that speech, and in this case specifically as applied, is it being attempted to be used as a cause of action for non-intimidating, non-coercive speech, it is unconstitutionally broad and vague. There's no way that Mr. Gillespie could have known what conduct was permitted or that this conduct specifically was prohibited if we read the statute to include what is alleged in the complaint. Your Honor, if you have additional questions at this time, I'd be happy to address them.
Well, I guess that also goes to show a reasonable person. I mean, a reasonable person would suspect that waterboarding would be, unacceptable coercion, whereas just having the conversation, a reasonable person would say, yeah, that's just having a conversation.
But otherwise, I will reserve the balance for rebuttal.
All right. At this time, the court doesn't have further questions. We'll hear from plaintiff's counsel.
Oh, don't you worry.
Thank you, Your Honor.
You're here just when you need
Your
to be
Honor, I
here.
would like to start where the defense started, with the allegations in the complaint and whether under 12b-6 that is sufficient to state a cause of action here. In reviewing the complaint, the specific paragraphs and the attachments to it, it is sufficient, Your Honor, to state a cause of action. In looking at, for example, paragraph 11, the allegation is that Mr. Gillespie said he did not want a bastard child. He would have no involvement in its life, nor pay child support. So he'd withhold any kind of financial support for the child. Paragraph 14, he would refuse to contribute to the relationship until she terminated the pregnancy. Paragraph 35, he threatened to call law enforcement on her if she hesitated to get an abortion. If you look at one of the attachments to the complaint, when I was reviewing the filed documents in the court's file, it was from part 2, I believe page 7 on the right side. And in a text message, it said, by Mr. Gillespie, if I don't get a say, then you don't get money from me. And he made it clear in that context that he was in favor of abortion. So these statements, Your Honor, do constitute coercion.
Could be,
Defendant's counsel is correct. There is no definition in the statute of intimidation or coercion. Courts have long held that even if there is not a definition, then the court looks to what is the normal definition of these phrases in normal life. And so if you look...
Well, and this guy is making a valid point. Would that be considered coercion? I mean, would that be considered coercion if they're having a conversation and she's saying that, one thing, hey, Jay, how you doing? Good to see you. Hey, Jay. How are you, Jay? I mean, that is some pretty strong language. Was it a conversation or was it email between the two? Because apparently it sounds like there was an email. I could see the attorney's point of this. If but you would also have to put those into context of what was being discussed at the time. Just, and this is something that lawyers are really damn good at, is taking a whole conversation that's happening and then clipping out a small section of it to twist it into something that it may not be. It's one of those where, he's presenting this, but we'll see exactly what his rebuttal is to what's being said. Because I mean, just on the face of it, it sounds like that could be considered coercion, saying, that, under no circumstances are you supposed to have this child, and I'm not going to raise a bastard child. Those could be considered, but like I said, you'd have to put it all into context. So he's making some pretty valid points, I think.
Look at, for example, the Merriam-Webster dictionary, which is often cited. The definition of coercion is the use of express or implied threats of violence or reprisal, such as discharge from employment, or other intimidating behavior that puts a person in fear of the consequences in order to compel that person to act against his or her will.
Yeah,
now,
that is true.
I do want to be clear that while my colleague has cited various criminal statutes as what obviously would qualify as intimidation or coercion, that is obviously the highest and most strict standard. This is a civil case. We're not in a criminal case. And so the standards from dictionaries and other items that are common to people do apply, as well as these criminal standards.
So I wonder, do we have any lawyers out there in the chat? I wonder if somebody threatening you with a lawsuit would be considered coercion. Well, I'm curious. Maybe if there's an attorney out there, they could look at it. I wonder if that would be considered coercion, or intimidation. Yeah, that sounds a little bit like it. But hey, I'm no attorney. I have to look into that.
And one case that I would cite,
No, you're not,
Your Honor, as far as when lack of a dictionary definition does not compel the statute to be void for vagueness or otherwise unenforceable, is Franklin v. Clement, 240 Arizona 587. And in that case, Your Honor, the court specifically discussed the void for vagueness doctrine.
You should.
But it goes on to state that, if I can find it, 1 second here, Your Honor. As long as a statute allows a person of ordinary intelligence to reasonably understand what is prohibited, it will not be considered unconstitutionally vague, even if it is susceptible of different interpretations. And the court was discussing what under the influence means in that case, which was not defined. And so the fact that it's not specifically defined in the statute is not fatal. But, Your Honor, the specific allegations in the complaint are enough for the court, as the court held in its initial 12b6 order regarding the first motion to dismiss,
yeah, doesn't it?
For a jury to find that, believing and taking all inferences in favor of the allegations of the complaint, a jury could find that it is proved. Now, as far as the statute and whether or not the statute allows a claim,
hey, MQ.
under
Well, thank you so much, MQ, for the 2 spot there. That is nice of you. Very much, MQ. Invest in some eye drops, pet. Yeah. Invest in some eye drops. I mean, would it be coercion if someone does something so egregious as wanting to sue?
Under paragraph G, Your Honor. I believe that subsection K, or paragraph K, however you would like to refer to it, of the statute, and of course I'm referring to the statute in the same way the court did. I think another key phrase, other than the one that the court pointed out, is any of the following may file a civil action to obtain appropriate relief for a violation of this section. And it doesn't refer to subsection A, paragraph A alone. It refers to this section. And so that includes paragraph G, which is a person, you know. It includes paragraph I, which also indicates a person, which that allegation is not present, Your Honor, but to the extent that the defense indicated that this action could only be brought against a physician, it's clear that throughout the statute it references what a physician cannot do, what an individual cannot do in subsection E, what a person
Ask
cannot do in subsection
about threats.
F, G, and I.
Oh yeah, I mean, you don't even have to ask Rock about threats. All you have to do is just look at your laws, and it'll tell you the kind of behavior that's considered coercion. What extortion is. It'll tell you that certain behavior is highly against the law. And, you know, most likely whenever it's handed over to authorities, cause a lot of problems on somebody.
And what an abortion clinic shall do in subsection H. So when you look at K and that it is for a relief of this section, not specific to any certain subsection, that has to include all of these, including G. And one of the individuals that is able to bring an action is a woman on whom an abortion has been performed without her informed consent. Now, another issue of statutory interpretation that I think is important for the court, because as the court knows, the reason for statutory interpretation is to effectuate the intent of the legislature, as indicated throughout the statute and not specifically only one subsection, is so looking at the different types of individuals specifically listed, a woman, a father who is married, not just any father, but who is also married to the woman, and then a maternal grandparent. I find it interesting, Your Honor, that they can bring an action for a violation of this section, but it only references informed consent with regards to the woman's ability to bring an action. In number 2, the father of the unborn child, there is absolutely nothing in that says that it is only if there was informed consent. And one thing that the legislature and another canon of statutory interpretation is that we can't interpret statutes to that would give an absurd result. And so,
no, I agree with him there. You can't have statutes that show an absurd result. But you know, if he's just making a request, and it would, like I said, he would have to hear in context exactly what he said.
If the court were to find that there was no ability to bring a cause of action in this case because the woman's ability is limited to a condition precedent, that there was.
I'm not sure when the next one is coming up. I know that there's supposed to be because they've already had a a hearing, and that's one of the reasons why she was arrested. But over the next few weeks, we're going to be showing quite a bit more of the kinds of shenanigans these attorneys are playing back and forth. So you can sort of see where some of their logic is going to be coming from. Not sure. No way. What the world has become. What has the world become? A place that's always worth being in. What did Captain Ahab say when he met L.O.? There she blows.
Not informed consent, but a father could bring an action under G that is married. It goes to an absurd result, Your Honor. And so that's why in looking at the interpretation and looking at the broad public policy of this statute, which is to protect a woman's right to be informed about her decision and not to be coerced into making.
So would it be informing that if he says, if you go through with this will be the results, or would that be coercion? That's sort of the question there. If he says, this is going to be the outcome if you do this, as compared to, saying, and having that with an intimate partner of saying, if you're planning on doing this, you're wanting to go through with this, and you've already made it clear to me that you're not interested in this, and you're using this to intimidate me into marrying you or doing something else. I think he was actually saying, that we're going to get married, or maybe he didn't. Doesn't matter. That's their intimate, private conversation. But if he's having these kinds of conversations with her and telling her, like, this is the outcome of what would happen, and putting his foot down. Cute. Well, baby, it's a man. Just male doesn't mean man, just means male. It's sort of like email. You notice they don't have anything called female. It's all email. I mean, males from the world.
In that decision, limiting her right to bring a cause of action to only a specific set of circumstances, whereas the father has an unfettered right, a married father.
Well, no, yeah. So he's saying, "Oh, a married father." Now you got to be. This is where you're getting into specifics. Oh, what do you? Speaking of sperm whale, what do you? When you cross one with a humpback whale, it's a comeback. This message brought to you by the letter H. The more you know.
Would lead to an absurd result. And I think if you continue to look at subsection L, and I'm going into a lot of detail because obviously I wasn't able to file a response here, and I want to make sure that all the points are covered, Your Honor. But looking at subsection L, I think also lends to that interpretation that this is not only against physicians. This is.
Well, let's put it this way. You say Yamaha, she's eating breakfast and almost made spit it out. You almost made her spit it out. I guess somebody else should have probably done that too. Sorry. Oh. Damn it. Oh, you're killing her. Oh.
Against any person, just like Mr. Gillespie. And if you look at subsection L1, again, you're able to bring a cause of action for money damages for all psychological, emotional, and physical injuries resulting from the violation of this section. Not just the violation of subsection A for informed consent, but a violation of this section in full. And so if the court were to interpret this contract or the statute as precluding this claim. I think that would be against the public policy in which this was enacted. In that vein, the motion cited the doctrine
there's some motion.
expressio
I'm telling you,
unius,
there's some motion.
and I might be butchering that pronunciation, Your
You're
Honor. But
probably.
as that it should be applied in this case to prohibit this claim. One thing that was not mentioned in that is this doctrine is not to be applied where its application contradicts the general meaning of the statute or state public policy. And so my client's position is that if the court were to apply it to limit the claim herein, as the defendants are alleging, it would contradict the state's public policy here to protect a woman's right to make this decision without coercion and to be informed about it. And this language comes directly from Southwest Iron and Steel Industries, Inc., the state,
Lord, I haven't had my coffee.
123 Arizona 78, which was cited in the motion by the defendants. And so for those reasons, Your Honor.
Well, at least we know that I have my favorite sound tonsillectomy. Did they? Oh, I'm sorry. This is what I meant to pull up. Did they add male feces to Larry's charges? No, I've been talked there. Well,
I believe the legislature specifically intended to allow this type of a claim to go forward.
Well, so your argument, counsel, is that your client is not one of the three categories of people under subsection K1, 2, or 3, but that essentially the legislature erred
come again
when it had included the phrase without her informed consent in subsection K1. Is that accurate?
Let me clarify that, Your Honor.
Good.
Thank you for that question.
Good. I like this. She's laughing.
My position is that within this doctrine, right, within K1, a woman on whom an abortion has been performed without her informed consent is the fact that there has to be consent, period. And if you look at this whole heading of this section is informed consent. And then it goes on to say requirements, information, website, signage, violation, civil relief. But at a base level, my client didn't give consent to the abortion because it was overcome by the coercion.
It was definitely overcome, that's for sure.
And so that is how the court should interpret that specific provision in K1 in finding that my client is entitled to bring the cause of action as an individual under K1. And again, looking at the absurdity of it,
not KY.
If she wasn't able to, as a single woman, so there was no father of the unborn child that was married to the mother at the time she received the abortion. So the legislature didn't intend to penalize single women under this statute and leave them out of any ability to bring a violation of subsection G or I or subsection E, which in looking at the motion, Your Honor, the defendants indicated that Mr. Gillespie could be liable for, I believe it was 36-2155, which is obviously a separate section, but it is the exact same language as under E. The very same phrase, an individual who is not a physician shall not perform a surgical abortion. It's just in a separate section, and that separate section does not contain a specific civil cause of action. Does that answer your question, Your Honor?
Yes, thank you.
Well, with that, Your Honor, I'd like to move towards the constitutionality piece of the motion. The first thing I think that needs to be noted is the courts have long held there is a strong presumption that a statute is constitutional. So the defendants start on an uphill battle in bringing an action claiming that this statute is unconstitutional. There is a presumption that requires the challenging party to establish that unconstitutionality, and any doubts are resolved in favor of upholding the statute.
Well, I think that he's done that. I think that he's been pretty. I think he's been pretty straight up.
And that is that it's throughout various cases, Your Honor. If there is a specific case I'd cite to, it'd be Ramirez v. Health Partners of Southern Arizona, 193 Arizona 325. But getting to the void for vagueness argument, as I mentioned earlier, the test is whether the statute gives a reasonable person of ordinary intelligence a reasonable opportunity to know what is prohibited. And so just because it might be hard to tell exactly what side of the line some speech is on, does not mean that the statute is vague, unconstitutionally vague. And another general rule of law that courts are to.
Well, in this case, there was no unborn child, so there was no father. I hope all the protective orders are rescinded when her felonies come home to roost. I don't know if that's what'll happen, if those protective orders will go away, or they'll just end up going away on their own. I mean, there's always that possibility that you can bring those to the court and say, hey, these are the kinds of things that she's done. She's been convicted of it, and probably get those protective orders removed. Not that he wants to have anything to do with her. I'm pretty sure he's just like, I don't have anything to do with her. I just don't need this stuff hanging over my head. And she certainly didn't blow it. How does that cleanup crew look on her resume? Is there a guess on how much time she will get? There's quite a few guesses, but I don't know if any of them are correct. It just depends on whether she's whether the state decides to ask for consecutive, or if the judge asks for consecutive or concurrent. That could depend. She also has to be found guilty. There's a difference between being guilty in the public eye and being guilty in a court of law, because the court of law is what determines it. You can sit here and think all day long that she's horrible, evil, blah, 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 all that kind of stuff, that she's lied. You can think all of those things. Now, what matters is in court, just because someone's charged with something does not mean that they're actually guilty until the court process is done. And once that court process is done, then you can make a better determine that way. I mean, you can make some wild guesses on how people feel about it, but that doesn't necessarily, that just matters, outside of the court system. That public opinion can mean quite a bit. So, you can't monetize it, but it can stop you from making one yourself. Yeah, I guess. I don't know what that means, but okay, Henry. Thank you. Her mugshot looked like she was in the process of swallowing something. No, she was just lubed up. That's all. Mr. Owens. She find out she cleaning the carpet. Maybe.
As courts are to interpret these statutes in a manner that is constitutional. So when the motion tries to intimate that this statute is too overbroad because
it's
it
overbroad,
really
that's for sure.
According to the subjective feeling of the person, whether or not they were intimidated or whether or not they were coerced, that's not what the statute says. And that's not in the vein that the court should interpret.
Oh, there's lots of veins.
That's not the way that
she's counted them all.
A person's ordinary intelligence would interpret it, because that's adding words to the statute. That would be saying that the statute indicated a person shall not make another person feel as if they are intimidated or coerced. And that's definitely not what this statute says.
Well, maybe he felt intimidated and coerced because he didn't want to have a relationship with her. That could be, interpreted that way. Greg Gillespie has been severely impacted by this. I believe he lost his job opportunities because of it. Yes, absolutely. Absolutely, Alman, that you are 110% correct. Greg and Mike both lost job opportunities for sure. Yeah. Yeah. And that right there is the outcome of those kinds of things. If it's affecting his ability to, in case it's getting too hard to swallow. Well, you know what? We've got the Bigfoot sketch. It was all veiny and bigger than mine. We'll probably show that one too. Oh, okay. So what we're going to do is the volume is going to increase. So those of you that are hanging out and have got your microphones turned up, I'm letting you know now that the volume will be increasing in 3, 2, 1. The volume is back up because what I'm going to show you is what Yamaha is talking about because it's so awesome. Oh, and then we're going to have a nice little open letter. I hope you enjoy the nice open letters because we're about to have a good one today. Let me pull this one up first for you. So give me just a second and let me find it here because it is absolutely wonderful. And I think that it should be, shown. Oh God, let me find it here. Yes. Where is it? All right, here we go. Give me a second. All right, here it is. This is what he's talking about.
So, she just said her name used to be Kyle. I respect it, just wasn't ready to meet the extra fork on the first date.
Just got to third base, turns out it was bigger than mine. Fuck that, I'm out.
I ain't even mad she had one. I'm mad it had veins. Bro, it winked at me.
All right, here comes the letter. You know it's coming whenever I do this. I don't have it loaded up in this one. For some reason I thought it was there, but it's not. Let me switch things here. Just so I can get this up here for you. Yes, here it goes.
It is about time. Let's break this mother down. With Shizzywhiznut.
An open letter to the serial evidence enthusiast. with selective memory card, bringing tech failures, misconduct, and untreated main character syndrome to the Arizona courts since always. Dear Madame, who's definitely not guilty, just ask her. Some people lie on accident. Others lie like it's a full-time job with dental. You've managed to elevate weaponized incompetence to an Olympic event. Gold medal in confusing USB drive, silver in perjury light, and bronze in the 100-meter dash from accountability. There's a special kind of performance art in sending a video to a regulatory board, watching it blow up in your face, literally, and then pretending you were just a mail carrier. I didn't alter it, you insist. I just knowingly forwarded a chopped up version of reality to a licensing authority while leaving out the part where it was manipulated. Bravo, really? Meryl Streep should be worried. Let's cut through the Oscar-winning dramatics, shall we? You claim innocent because you didn't personally alter the video. Well, that's cute. That's like saying you didn't rob the bank. You just drove the getaway car, counted the money, and deposited it in your account. Intent isn't erased by the lack of fingerprints, and no, I didn't know doesn't fly when you've been caught red-handed with a heavily curated timeline, carefully packaged for maximum damage and minimum truth. Well, you submitted a spliced video to a state licensing board, one that just so happened to leave out the part that contradicted your narrative. But don't worry, everyone. She swears she didn't alter it. She just relayed it like a dishonest carrier pigeon with a grudge. And then you had the audacity to argue that it's not tampering because technically you didn't do the editing. Well, that's like saying you didn't set the house on fire. You just poured the gasoline, handed over the matches, and suggested an arson group in a chat group. Well, that's a bold move, and let's see how that plays with the felony statute. Oh, speaking of timelines, let's address your favorite excuse. This was before the criminal investigation started. Oh, sweet summer child. The law doesn't hit pause just because the cops haven't rung the doorbell yet. Tampering with evidence doesn't require a badge in the room. It only requires intent to mislead someone in authority. The Arizona Medical Board counts, and so does common sense. What's even more impressive is your high-wire act of trying to pass off two competing versions of the same damn video. One just happened to be missing the part that clears the target of your complaint. Whoopsie. Must have been a clerical error, right? Totally understandable if you were forwarding cat memes, but not formal evidence in professional licensing matter. Let's not pretend this was a good faith mistake. Well, you're no rookie. You've litigated complaints like it's a hobby. You know how these systems work and how to weaponize them just enough to think you'll get away with it. Let's see, the trick to playing dumb and not getting caught holding the playbook. And when there was your courtroom debut, stammering through USBs like a confused intern on her first day. Pro tip, if you're trying to dodge a felony, maybe don't treat your evidence folder like a $5 grab bag at Goodwill. I labeled it maybe 15 or started at 55. I printed something. Well, you sounded less credible, defendant, more like a kindergarten teacher explaining nap time, only less prepared. But hey, I get it. When your case starts circling the drain, feigned confusion is easier than accountability, and now you've got an entire defense strategy built on, oops, I sent the wrong file. Oops, I didn't verify it. Oops, I had no idea someone might consider that misleading. Oops, I didn't swallow it all. At this point, the only thing tampered with more than the evidence is your credibility. You gambled that no one would ever notice your edits or your intent. And now you're shocked, so shocked that the court isn't buying your little game of evidence telephone. When the ruling drops, I bet the only thing getting dismissed is your fantasy that this won't catch up to you. When the judge asks whether forwarding misleading material about a disclaimer might qualify as tampering, the prosecution mumbled something about context. And you practically wave from the gallery like, yeah, I'm the context queen. You are. In fact, you're the reigning monarch of manipulating context until it's indistinguishable from a Reddit conspiracy posts. Corny and legally unimpressed, the guy with Velcro shoes and receipts, aka Shizzy Daddy, certified nut job and keeper of the USB stick of doom. Yeah.
It is about time. Let's break this mother down. With Shizzywhiznut.
Yes, yes, yes. So much fun. Everybody, I hope that you have a wonderful day. It is Tuesday. The sun will be out today in most places. And if it's not, well, then use a damn umbrella so you don't get wet. Or use an umbrella if it's too hot out, because it might shield you from all those harmful UV rays. You know, the ones that make your skin glow red. I hate those damn things. Holy testicle Tuesday. What the hell is going on here? Good to see you, MG. I hope you're having a wonderful morning. I hope you're not driving too fast. And if you are, make sure that you do swerve. It's good to see, brother. I hope you're having a day. And everybody, go over, show Mo some love. I'm working on some new stuff with Mo. I hope that you guys can join me very soon. I also do have some more deposition readings that I plan on doing. I just need to work all that stuff out, because I've got Mo, I got deposition readings I'm going to be doing, and those are with all different people, or maybe Mo will join in. We'll see exactly what happens. But we've got something we've been talking about for quite some time, and it's something I've covered before. And I hope that you guys enjoy what we're going to show you, because it's going to be off the rails, wild, crazy stuff. Everybody, have a beautiful day, and don't forget to hit that like and subscribe if you haven't done so already. It's turning out to be like Ace Ventura. Yeah, that's about right. Stephen Bear, good to see ya. Everybody, see you tonight. Peace. Peace.
It is about time. Let's break this mother down. With Shizzywhiznut.